Jim, good afternoon.
It has trickled in.
Thanks for being here. And if you will state your name and your affiliation, your position on the bill.
Good afternoon, Chairman, Madam Vice Chairman, members of the committee. I am Jim Perdue, Jr. from Houston, Texas. I'm currently president of the Texas Trial Lawyers Association, and I'm here against House Bill 19. You understand who the Texas Trial Lawyers Association is. It's an association of lawyers who represent individuals and businesses across the state in civil litigation of all different issues. There's some over 2,500 members now. You heard last week from the chiefs of both of our highest courts in this state, and you heard from Chief Justice Hecht talking about the state of the judiciary. And I can tell this committee that Chief Justice Hecht, literally in March of 2006, invited me to serve on the Supreme Court's Rules Advisory Committee, which advises the Supreme Court on its rulemaking authority, and I've had the honor of serving on the Supreme Court's Rule Advisory Committee for the last 15 years. I additionally serve currently as an advisor to the American Law Institute on the third state restatement of torts and its project to finally finish the third restatements of torts in its concluding provisions section, which has been was started by the great Bill Powers some 25 years ago. So I come to you today after hearing Chief Justice Hecht, who I have worked with for a decade and a half, in which he said in his comments, and they were echoed by you, Chairman Leach, justice delayed is justice denied. And that is not just a saying, that is an undeniable truth. You then heard from two district judges in our courts, one of which who lost his courthouse to a fire, another of which is on the cutting edge of virtual proceedings and gave you an address from their perspective of the judiciary. And when they finished, this committee joined in recognizing the hard work that our judges do in delivering justice equally and fairly across the state and trying to get it right. And that, too, is an undeniable truth. The judges across the state of Texas take their responsibility and their oath of service very seriously, and in my experience, do all they can to get things right. House Bill 19 starts from and ends with a policy proposition that stands in complete contradiction of those two facts. House Bill 19 is designed to create unprecedented delays in both the process, delivery, and finality of justice. House Bill 19 micromanages discovery decisions, evidentiary rulings, causes of action, and then judgment formation. In its final analysis, the reality is that House Bill 19 is a radical remaking of the civil justice system for a specific classification of defendants. And this committee is going to hear from several interested constituencies on both sides of this issue. I know that there are people who have strong feelings from the business community about the litigation atmosphere, but likewise there are people, not unlike, and my apologies to Lee for his loss, not unlike those that have been lost just walking across an intersection. If I may begin with 72.008, which is the future periodic payment of damages section of the bill. It was just represented that that section of the bill reflects a policy decision that was made by a prior legislature. That is simply not true. 72.008 is not the language from Chapter 74. It doesn't follow it. It doesn't track it. It substantially changes. And no legislature has ever made this policy decision in the past. And it reflects the two primary goals that I've talked about of delaying justice and not trusting judges to do their jobs. In Chapter 74, on the periodic payment that starts in 74-300 series. There are multiple provisions that deal with periodic payments in medical malpractice. By way of history, Chairman, I was unfortunately involved in the HB3 fights and HB4 fights in 2003. Representative Schofield, you remember those as well? And I actually testified on this section of the bill. This language comes to Texas courtesy of the MICRA statute in California, which is their tort reform statute that dates back to the 70s. It is not used in California because of the impossibilities it creates. This statute is not used in medical malpractice because of the impossibilities it creates. But even if you were going to suggest that a prior legislature has made this policy determination regarding future damages, you would at least track the language. But because this bill does not believe judges are capable of doing their job, it changes the language. And it says that a court shall take all future damages. It doesn't distinguish between the elements of the future damages. It says it shall take all future damages and roll them in to a periodic payment program or some other thing. Now, here is the functional problems that cannot be fixed, because this is not simply a question of who the remainder interest goes to. The remainder interest going back to the defendant himself or herself is perverted on its face, quite frankly, but the reality is this. Chairman, Representative Smith, you talked about how a case is tried. I'm going to get to the end of the trial, but it goes to the jury charge. Representative Schofield, you know this as well. A jury is asked what sum of money, if paid now in cash, would compensate the plaintiff for the losses they have under tort law. And by the way, the whole point of tort law is to hold the wrongdoer accountable as opposed to society for the losses that they have caused. That policy decision that is reflected in 200 years of tort law is the idea that the tortfeasor then is called on damages, even those for the future, to bring them into present value, and a jury is asked what sum of money if paid now in cash. This bill disregards that fact-finding. And so it takes the sum of money if paid now in cash, and then, because it doesn't track the Med-Mal statute, it says the judge shall, on the defendant's motion, take the jury's decision of what sum of money, if paid now in cash, and despite being asked that question in that way, change it into payments in the future. Now, here's the pragmatic problem, Mr. Chairman. In a settlement context, on somebody I represent, I have a fiduciary responsibility at the highest level when it comes to putting money away for somebody who was left a C8 quadriplegic because a truck hit them from behind. I have the highest responsibility in the law to make financial decisions and get financial advisors in a settlement context on behalf of the people I represent in a private context and in a private transaction to make sure they have advisors who also have a fiduciary duty to them, in which their money is either purchased in the insurance market through an annuity to provide a future income loss stream to them, for example, or put into trust to provide for a child who has lost a limb or has been injured. Those private decisions, which are held by private individuals, are defined both by contract, and then the relationship is set by people who are advising them with a sole duty to them and advising them in their best interest. This bill would take those relationships and that priority off the table and move it onto a judge who is taking advice purportedly, according to the terms of the bill, from the defendant as to where to put the money, with whom, and for how long, and under what terms. So in this bill in concept in today's marketplace, annuities currently are getting about 1.9% internal rate of return on a long-term basis. If I had a person who had been injured in a truck wreck with a future of 20 years of medical expenses or a future work life expectancy of 25 years. And I had a private transaction where the marketplace and my client, who I owe a duty to, makes a decision. I don't want to put it in an annuity and lock in 1.9% for 20 years. I want to have it in a trust that has a duty to me that can invest that money and achieve a 7% rate of return. And that trust advisor then has a responsibility to me to make sure they don't lose it, but also try to gain a return. This bill takes that off the table, and that ability to achieve what the marketplace would provide for an investment return, and allows the defendant to do it. And here's the next then pragmatic problem. In the marketplace of insurance and life insurance, as the committee knows, you've got AM Best 15 rated companies and you've got AM Best B rated companies, and below that. So a judge or a defendant can go out and, first of all, they take a present value dollar, they buy a future payment scheme, so they've double discounted. The jury has awarded the money in present value for future damages. The cash in 2021 must be able to buy $1 in 2041. $1 is not worth the same. So now they're double discounting and going by an insurance product that will create a payment of, let's say, $4 million that was awarded by the judge, and they'll take whatever amount, I guess after fees, which is not addressed in this bill and is addressed in MedMal, and put it in a product that goes out to the future. And then here's an extra weird thing. Future pain and suffering and future mental anguish is not on a schedule. The bill is contemplating the concept of medical expenses or work life expectancy, but it says all damages. So according to the terms of this bill, and again, this is different language, it takes all damages, including pain and suffering, physical impairment, which is not on a schedule, and for which this is especially offensive for a wrongful death beneficiary whose wife or child was killed in one of these accidents, and their damages are only loss of consortium and mental anguish, only non-economic damages. There is no schedule for future mental anguish or loss of consortium. And this bill mandates that that gets put on a schedule. Well, there's no evidence that allows a judge to do that, even if it could be done. There's no evidence of a wrongful death beneficiary life expectancy. It's completely irrelevant to the issues at trial. Whether the child be 8 or the widow be 30, the evidence of life expectancy of a wrongful death beneficiary is a completely irrelevant question. So there's no evidence in the record. A judge has to make a determination on what it's unstated and unknown. And again, with this perverse incentive that if they don't live that long and develop COVID in the interim and die, then it comes back to the defendant. And they can put it into whatever structure they want that may not survive the financial risks of the marketplace. So if the judge or the defendant chooses an AM Best 5, that there's a financial crisis like we had in 2007 that disappear from the marketplace, and they're no longer able to satisfy that obligation, the person left has got a future income stream which was chosen by the defendant and unknowable and lost. And then the last perversion. In the commercial context, oftentimes you have some of the biggest international carriers that are the insurers. So you could see CNA or AIG have commercial liability policies. CNA and AIG have life insurance companies. You, according to this bill, can allow the defendant's insurer to sell itself or buy from itself an annuity life insurance policy, profit on that from that side of the benefit, on the side of the business, benefit if the plaintiff doesn't live to their life expectancy, and build in themselves as the contingent beneficiary. In medical malpractice, at the very least, it does not say shall. And in medical malpractice, when it does say shall, it says all or part. But it does say may regarding all the other elements of damages for a reason, because we believe in judicial discretion. But nobody uses it because of all the pragmatic problems I've just described for you, Chairman. This section cannot be fixed. And quite frankly, this section does not reflect any policy priority of the commercial trucking industry. There's no service in future damages being periodic payment to these individuals who want some relief from lawsuit abuse. They're not here looking for relief from judgments. They're looking here for relief for causes in the system. This is a creation of a think tank designed to deprive a plaintiff from being made whole.
Representative Johnson.
Thank you, Mr. Perdue. I just, while we're on, I know this bill is complicated. I'm sure you're going to address multiple issues, but while you're on the subject of periodic payments, I had a question. Take this off so you can hear me. You know, one of the things that concerns me about the periodic payment, and I'd like you to speak to this if you would, is kind of a point that you were just trying to make. There's no regulation in here as to the standard of annuitization for the rating of a company or how the investment models will be made, and what happens when that carrier defaults on its obligation. What then happens, it's my understanding, if they have an insured product, let's say you have a defendant and their insurance carrier is required to now annuitize $3 million over 20 years, but that, and so that's the defendant's risk, but then that carrier defaults. So by the way the law reads now, if I'm not mistaken, that default will then not go back to the underlying defendant, but go to the Texas Guarantee Fund, putting the liability on the path of the Texas taxpayers to pay the unfunded judgment because the carrier defaulted in the annuity. Is that your understanding?
I've had the misfortune of having a judgment that had not yet been signed against a company that was insured by a company that went into the Guarantee Fund. And the Guarantee Fund is a fund of last resort when an insurance company defaults in the state of Texas. It leaves, regardless of the coverages, the claimant with a $300,000 policy. You go to the receiver in the Guarantee Fund who addresses the claim within the Guarantee Fund. The maximum recoverable is for $300,000. They owe no duty under the law in any form, even to the insured or the claimant. And so there's an additional question to the idea of default, because on a periodic payment program, the contract would say you can't liquidate it. So if you've got future periodic payments for an additional $1 million, but the periodic payment program says you can't bring that to present value and liquidate it, so you couldn't even get the $300,000 that's available to you in March of 2021. I know that's very technical and complicated, but in the insurance context, that is exactly the risk of not having, because here's the number 4 in this section, says any other satisfactory form of funding suggested by the defendant making the payments and approved by the court. So it forces the court to do it, but then it suggests that if a court does approve a payment of any satisfactory form suggested by the defendant, there's not even a securitization in that instance. So the defendant can say, I'm good for it for the next 10 years, and if the defendant's not there next year, that judgment is gone. There is a raft of problems with the way this works, and quite frankly, the reason judges have acknowledged it and is because of not just the pragmatic issues that I've identified, hopefully, in my efforts here, but in the fiduciary responsibility, because the proposition is, well, plaintiffs put things in periodic payments or buy annuities all the time. That is true. In a private transaction, with individuals have responsibilities to them, and if they fail in those responsibilities or those financial decisions are not met, then they have a cause of action back on those advisors for putting them in there. That happened back in the 80s when the insurance crisis happened and the interest rate market. There are a lot of people have been putting annuities, and a lot of lawyers have made some bad financial recommendations, not unlike the savings and loan crisis back from the 80s. Similarly, you had secondary liability in that. This is an existential risk that is a massive, massive change in tort law. And quite frankly, if the priority of the bill is some relief for a litigation environment for commercial motor vehicles, it does not even serve the stated priority of the bill. Let me talk about the next radical change in the bill, which is bifurcation. We have bifurcation in the state of Texas. We have Chapter 41. It was part of the tort reform package of 1995. Bifurcation was enacted into the law as part of our caps on exemplary damages. So we have caps on exemplary damages since 1995. They are in part achieved by bifurcation. I heard an analogy of bifurcation to the way criminal trial practice, of which Speaker Moody is familiar. And yes, there's essentially bifurcation in criminal practice. You try the crime, and then you try punishment. This bill would say that you can try the bank robbery, but you cannot allow the jury to know that they killed a bank teller in the process for the crime of felony murder, because that's bifurcated to the gross negligence analogy of the case. You try the liability part of the case because the facts are indivisible. That's current law. There are not gross liability facts and negligent facts because you have to be able to present the facts. So violations of standards, which seem to be a primary thrust of the bill, both from the discovery perspective and the trial perspective, which I want to talk about. It seems to be the implicit argument that if there's a violation of policies and procedures that led to a claim for negligent hiring, negligent entrustment, and negligent supervision, which I would really like to talk about, because there's a spectrum of those cases. We don't want the jury to hear any evidence, if we stipulate the course and scope, of either negligence or gross negligence for the claims on that spectrum from hiring to supervision, and only try the driver. And the question has been raised and asked, well, what if there is a policy and procedure for journey management and sleep reporting, and you cannot be on the road if it's a big rig under the Federal Motor Carrier Safety Act, subject to the Texas Department of Transportation, or just the company's own policies and procedures for hours of service. And so you have a 8-hour of service rule. And the driver falls asleep at the wheel because the company has been pushing him or her for 10 hours. And they fall asleep and cross the center line. Now, the company stipulates that person was in course and scope. But the fatigue is directly related to the drivers falling asleep. And the company has rules regarding hours of service and keeping people from getting fatigued behind the road. In fact, it's an undelegable duty under the Federal Motor Carrier Safety Act. You can't even delegate that to somebody else. If you have that evidence, this bill is designed to keep that evidence away from the jury, even in the idea that if you had gross evidence of it, it would keep it away from the jury. Because what this bill does, in a break from Chapter 41, and what Chapter 41 says is that in the first phase of a bifurcated trial, the trier of fact shall determine liability for compensatory and exemplary damages, and the amount of compensatory damages. So punishment, exemplary damages, works under Chapter 41 exactly same to the corollary to criminal cases. You put the punishment phase regarding exemplaries out of the jury, so the jury doesn't hear about net worth. The jury doesn't hear about financial wherewithal. The jury doesn't hear about those other things. But this rule, this proposed bill, breaks from that and separates in a very, very complicated fashion the idea that liability for one cause of action is tried in a primary phase, And conceivably, then you have damages, and this is where it gets impossible to implement. And then you move liability for gross, which they are now elevating to the predicate requirement to be able to get to the company under this bill. And then perhaps you try damages. So here's the problem, and Chairman Krause, you were picking up on it. There was a suggestion made earlier that the 1961 Patterson case is the law of the state of Texas and establishes that if a company stipulates to course and scope liability, those claims then eradicate, that stipulation eradicates direct claims against the company for hiring, entrustment, and supervision. I keep coming back to supervision, but here's the reality. We enacted comparative fault in 1985 through Chapter 33. And so juries in Texas since 1985 have been asked under Chapter 33.003 to consider the percentage of fault for each either plaintiff, tortfeasor, or cross-defendant, and assess those percentages only those that are a proximate cause of the injury at issue. So the self-limitation on proximate cause exists in current law. But the cases, there are multiple cases, Chairman Krause, Bedford versus Moore out of the Fort Worth Court of Appeals, that identifies that under our comparative fault statute, the independent claims against the company must be put into the liability case because a jury is required to assess everybody's fault. You cannot have a cross-claim situation. You cannot have a counterclaim situation. You can't have the ability to say the plaintiff had a 20-year-old back herniation and put their fault or their pre-existing condition into the case and then not say that the defendant company's responsibility and percentage must also be put into the case with the driver's responsibility. And here's the status of the law, because there's been a suggestion. This proposed codification does not represent the majority rule. And Chairman Krause, I know you mentioned this is the law in some states, but here's the main distinction. There are only 2 states in the union that I've been able to find of which they have a comparable comparative fault statute as ours that apply that common law doctrine. This common law doctrine, which was referred to Patterson in 1961, which predated contributory negligence, it existed in a time where pure contrib bar, a 1%, acted to bar, and the jury was not asked to measure percentages in fault. With the advent of comparative fault, and percentages become then a divisor to what the jury awards, and all responsibility is measured, the old doctrine of a stipulation removed from the law. Alabama, Arizona, Delaware, Georgia, Hawaii, Iowa, Kansas, Kentucky, Massachusetts, Minnesota, just in the last 10 years. Arizona, Oregon, Kentucky, Oklahoma, Tennessee, South Dakota, and I'll tell you again, Georgia in December of 2020 in the Quinn versus Halsey case. The Georgia Supreme Court ruled, yes, there is an old doctrine in the old common law, but we have a comparative fault statute. Their comparative fault statute reads almost identical to ours and requires an allocation of liability. And it says under our comparative fault statute, we cannot apply that old common law because now we have to assess fault. In 20 states that have comparative fault statutes comparable to ours, this is not the rule because of those rationales. You cannot achieve the goals of Chapter 33 and acknowledge the Supreme Court's pronouncement starting in Schneider or Williams versus Stevens or even TXI Industry, all of which says there is a direct cause of action against a company because a company has duties in its hiring and firing decisions. With the key distinction, if a plaintiff can't show that the hiring and firing decision was a direct proximate cause, the case shouldn't be submitted. And if they do, you know what happens at the Texas Supreme Court level or the appellate court level? They get reversed. And the vast majority of negligent entrustment cases that you read from the appellate courts take away the effort to recover.
How is the hiring decision not relevant if the employee is employed by the employer at the time of the accident?
How is the hiring decision not relevant?
Repeat what you just said.
So, for example, the best example, and this is the law of the state of Texas, is no stipulation, no issue. There was an allegation that the hiring of somebody with no knowledge of their driving history, but they should have known he was an illegal immigrant. That's the TXI case. The allegation was that they should have known he was an illegal immigrant, but there was no evidence they knew about his bad driving, and there was no evidence that he had a bad driving history. Driver then exceeds the speed limit, causes a wreck. Supreme Court says the hiring of an illegal immigrant is not the proximate cause of the wreck, and the hiring had nothing to do with knowing that the driver was a risk. Unless you had evidence that you wouldn't have hired if you had known the driver was a risk, that is the standard of care that is based in negligent hiring, then it can't be a proximate cause of the wreck. There's no evidence in the case that your decision to hire or not hire for the false social security number, which was the evidence in the case, is a proximate cause of this wreck. Unlike, for example, whether it be Bedford or another case, you have an evidence that you hired somebody whose employment file or a 3-year look back according to the TxDOT regulations would have exposed that they had multiple speeding violations and multiple driving incidents, and despite that knowledge in their driver file that they had been fired from 3 different common carriers, you hired them anyway. That then could qualify under Texas law. It's a pretty narrow, Mr. Chairman, exception. And so there's all this talk about negligent hiring and negligent...
Break this down for me, though, because in that situation, if the plaintiff's attorney, if I'm misunderstanding something, then walk me through this. In that situation, if the plaintiff's attorney is alleging that the fact that a defendant employer hired an illegal immigrant and the defendant's position is that's not relevant, but plaintiff's attorney is saying we want it in. We think it is relevant. So defendant then has to spend how much money to go get all the way up to the Supreme Court saying it's not relevant?
Well,
clearly that's not relevant.
So the issue of immigration status is a very complicated issue.
I'm just using that as an example. I don't want to get into
We're
not here to talk about immigration status. Let's think about another example. My point is plaintiff's attorney wants to make an argument that all this other stuff that has no causal connection to the actual accident is relevant and should come in.
So
defendant has to expend untold hundreds of thousands of dollars on that single discovery fight. Yes or no?
Well,
in order to ultimately prove that no, it's not relevant. It has no causal connection whatsoever to the accident other than the fact that employee was actually employed and had been hired.
So the question is asked again from the proposition that the judge will make the wrong ruling. If the plaintiff is seeking excessively burdensome discovery that has no relationship to the case, I'd be the first to tell you, Chairman Leach, that should not be going on and shouldn't be happening in the course and scope of litigation. I'd be the first to say that. But I will also tell you that we've got
lawyers that we've got presentations being given to plaintiffs' attorneys who specialize in this industry talking about and giving tips for in specific courts how they can get this information in.
Well,
if that's your position, I appreciate that. You're representing to the committee and to the legislature today that it is, but I hope in your role as president of the Trial Lawyers Association that you'll make that very public.
My position, I think for my members that are here and the people they represent is very clear that if you're pressing causes of action that don't exist under Texas law, you're not doing yourself or your client a service, because it does no good to get a judgment that is taken away.
Does the legislature have a responsibility and an obligation to, are we charged as the legislature, specifically this committee, with looking at the civil justice system and looking at the landscape of cases, and in some cases reining in the framework or providing more of a clear framework? Do we have that responsibility or not here?
So, Mr. Chairman, the responsibility exists, but it's at the highest responsibility, because if this committee or this legislature passes a bill that doesn't, in its specific language, reflect the meanings of the words and a reflection of the real state of the law by its terms alone, regardless of its intent to try to make the system better, if the language of a bill does not specifically through its terms achieve that, it is open to interpretation regardless of the legislative intent.
Stipulated. Agree.
And that
so
is...
let's fine-tune the language, but you're opposed to the whole idea of bifurcation.
I would be honored to work with this committee on language, but this bifurcation in this way, which breaks from Chapter 41, is the issue. The bifurcation in this bill is built on two premises. Number one, current bifurcation doesn't work. Number two, we are going to stipulate to liability and take direct action claims against the company, whether they be maintenance or supervision or whatever spectrum. But we are going to take the direct action claims against the company and move them into the second phase and put them on a gross standard. And as you know, Chairman, that then puts you in a situation where you have to have unanimous verdict. It is based on clear and convincing evidence. And you move all of that into a second phase after trying the liability, not the liability, but the liability of the driver. So whether it be what the jury hears or the pragmatic effect of bifurcation under the way this bill works, you're abandoning the principles of Chapter 41.
But not, you're correct, I think, but not for compensatory damages. We're talking exemplaries.
You're right. You're right, except that you're talking about the liability causes of action. And that's one of the challenging parts of this because it ignores the existence of Chapter 33. Because in this instance, and I think Representative Eiland can talk about the coverage situation and the insurance applicability for these claims, what you're doing, because you're not having a finding of liability in the first phase for or relationship to the company, you have the potential of moving the liability of the company for compensatory damages off onto now an uncovered claim. See, because the second phase, Chairman, is for exemplary damages. But you're asking them, are you responsible for negligent entrustment or negligent hiring? But you're asking them, are you grossly responsible for negligent entrustment or negligent hiring or negligent...
So is under the first phase, if defendant employer stipulates as to liability, compensatory damages are determined. You're saying that compensatory damages and liability are not determined there, that it can later be reversed in a later stage of the trial?
The liability solely on the respondeat superior basis.
But as to all compensatory damages?
As to all compensatory damages, yes.
Okay.
But what if there is insurance for all compensatory damages through the commercial general liability policy, and all you have is a case that is tried on the vehicular policy? So that's the problem with bifurcation. Let me just talk briefly, because you have other resource witnesses from me, because it was asked about the discovery process under this rule. This rule resets the default, Speaker Moody, on the way the system works, on the scope of discovery, and then, in the last step, on relevancy determinations and admissibility. And it moves the default of the law in every single setting of that in the steps of the process. 006C says that unless the parties agree, the seeking to use pretrial discovery to obtain evidence of a defendant's failure to comply with a regulation or standard must obtain a court order allowing the discovery. Now, the Texas Supreme Court just finished a 3-year project of trying to update the rules of procedure regarding discovery and bring them in line with the federal practice. We voted those rules out last, I believe, January or February. You probably may have seen the rule issued by the court for comments last June. They became final then in December and went into effect January 1st. So we have a redone Rule 194 that brings the state into compliance with federal practice, which now, Mr. Chairman, moves us into a mandatory disclosure setting, in that you don't have judicial intervention for the most basic discovery. So here's what this bill does. You can't get any discovery regarding a defendant's failure to comply with a regulation or standard without a court order. So you talk about the expense of litigation. Every single discovery fight under this proposition requires the parties to go to a court and get a court order in every single case for the whole spectrum of cases that this bill covers. But perhaps more, and I don't know if this is, again, words have meaning. If you look at the definition in E, a regulation or standard, which is the language of C, is defined. That it includes a statute, regulation, rule, or order, and that seems to imply the federal or state law. But then secondly, it is a restriction of discovery of the company's own documents and the company's own policies, because the second one says the defendant's policies, procedures, or statements. Well, witness statements are mandatory exchange under current law. You never have to seek a court order to get a company's policies, procedures, or the statements of an employee of the company. And I think maybe that word is not meant to be as literal as it seems to be used, but that's a definition. That word without definition, defendant's policies, procedures, or statements, conceivably captures a universe of discoverable evidence, which is the essence of being able to try even the liability case against the driver. So there is language regarding this, but it sets as a default that it is undiscoverable. And then if you work backwards in it, I can address the problems with mandamus. It changes the standard for mandamus in this draft. The standard for mandamus is clear abuse of discretion. This statute cleverly deletes clear and gives them a per se mandamusable issue. But let's go back to the presumption regarding, again, since the bill begins from a place that judges are not doing their jobs, it says in Section A defendant's failure to comply with a regulation standard is not admissible. So in C, you start the process of depriving the litigants the ability to get the information, but even if you did after a court order, and Chairman, I could talk to you about language of scope of discovery and work with this committee for language regarding scope of discovery, and I would be honored to be able to participate in such process, but then you move from the scope and the ability to get any discovery to the proposition that if you did get it, it is not admissible and cannot, in other words, it is not admissible regardless of the judge's finding of its relevance to the issues and will not support in judgment unless you can, and this is then, I think, Mr. Breslin's going to talk about the challenge of loose language and the way one works in combination with two. I will tell the committee, number two, that is that a reasonable jury could find the failure to comply with the regulation or standard was approximate cause, I think is consistent with TXI. And so a statement, a statement of the law that doesn't deviate from what the Texas Supreme Court has established would allow this committee to give guidance to courts, to parties, to industry, to plaintiffs. This is the law, and if it's coming in, it must satisfy that, but that's not what this does. It moves the default. It moves the default to non-admissibility, non-discoverability. And the problem with that is because the liability standard under this bill is moved to gross negligence, because Member Reach, I'm getting a long day and I don't have any water. Member Smith, you were asking about, the problem, the cross-claim analogy, which was a huge issue, but you're moving the liability case to gross negligence. And you're bracketing the discoverable issues to a time certain in this bill, 2 years. Well, Gross requires the plaintiff to be able to establish a conscious disregard and a pattern of practice. If the Gross standard becomes the liability standard, and under the rule you deprive a litigant of having any access to the discovery to meet that standard, then you are depriving the litigant of the very access to the court system, because there's no way they can get the discovery to satisfy the moved standard.
Representative Johnson.
Thank you. I share your concerns on the discovery, and I'm hopeful that, Mr. Chairman, we can talk about that as we're working on a committee sub. But I want you to address, since we're going to break for here, I wanted to get you to address an issue that's concerning to me, which is in the definition section of this bill. When it defines commercial vehicle, it seems to be when we're taking a look at the conduct, we're looking at the car itself, not on the purpose for which it is being used. And so what happens, the way this bill is drafted, for the, fill in the blank,
Thank you.
plumber who has a pickup truck, who is now having beers with his friends, they're not at work, and gets hammered and then runs into somebody. Clearly not in the course and scope of their employment at that time, but because they're in their vehicle that they use for commercial purposes. What happens in that scenario under this bill?
So the bill, by its terms, would capture sole proprietors. The bill, by its terms, captures my car, which is owned by my law firm. So that qualifies under this bill because it is a motor vehicle, and then this is the challenge of the language. Being used in interstate or intrastate commerce for the transportation of property or passengers for commercial purposes. The bill does not bracket the use of the bill of the car at the time of the event. So I know it's built from this premise that there's this course of scope stipulation coming down the road, but the bill as defined it doesn't tie this definition to 006. It just exists in the ether in 001. So you have a truck that is the plumber, my local plumber's truck. Local plumber uses that truck for his everything. That is a commercial motor vehicle because it's being used in commerce. He decides to go to the bar on Friday night and have 20 beers and 5 shots, and he gets back behind the wheel. Now, you have a long issue about where there may or may not be coverage on his commercial policy, which is irrelevant, but he does get the benefit of this statute because this says a commercial motor vehicle that is used in interstate or commerce. And I just don't think the word being is near enough to tie what perhaps is the intent, but the breadth of this is highly dangerous because you have every sole proprietor with a commercial vehicle, that there's a vehicle for their business, every single one in the state will be captured by this. And then subject to the discovery limitations, and most importantly, that driver, that drunk driver in his plumbing truck, gets the benefit of future damages and future periodic payments. And potentially the benefit of the re-engineered bifurcation so that his gross negligence for getting behind that wheel is moved into a second phase trial, and the jury has to somehow parse between the liability question of his negligence driving the car that night drunk for negligence and then his gross negligence in driving the car that night drunk. So I guess it's a concept, if you had his BAC at a 0.3, you wouldn't allow that in the liability case because that's evidence relevant to gross. That the challenges under Chapter 33 and Chapter 31 reflect this legislature's policy decision of comparing fault in a systemic fashion. And if there are discovery abuses, there's a way to write a bill. If there are claims that shouldn't be in cases, there's a way to write a bill, in my humble opinion. And I would be honored as a resource to this committee to assist in that process. But this insinuation has been made, and I I will tell this committee that I am not. I'm not a specialist as a motor vehicle lawyer. As Representative Schofield knows, I kind of do different things. But I've learned a lot about it, and I'm honored to have been here. There was a comment about the increase in filings. And, the litigation environment, and apparently, as Vice Chair Davis has pointed out, has been honestly testified to by the constituencies here from business that this is a national issue, that they're seeing the liability insurance issue in Louisiana across the border, that they're seeing cases that they don't like and the way they're being developed or tried across the country. And as this committee knows, the vast majority of commercial traffic is interstate. And even if it is intrastate, the insurance market for commercial policies has impact for interstate commerce and the events across our border. You're trying to suggest there's a policy proposition for citizens of the state of Texas, but this bill protects Mexican truck companies. It protects Utah truck companies. It protects truck companies that are based in Tennessee. It protects oilfield services trucks that are from Oklahoma. If the wreck happens in the state of Texas, subject to the venue and the laws of the state of Texas, those companies get all of these protections. But their insurance rates are based because of a national analysis. And I'll leave it to Representative Island to address that. But I will just leave the committee with this, because Texas has done a lot in its effort to make this state a great place for business. And so it's not just population increase, Representative Johnson. But the data points for the information provided to the committee from the Trucking Association were 2008 and 2019. In 2008, there were 9,280 trucks on the road. In 2019, there were 14,272,000 trucks on the road. Truck trailers in 2008, there were 182,000 trucks, and truck trailers in 2019, 275,000. There's a 53% increase of qualifying trucks and truck trailers, according to the United States Department of Transportation, Federal Highway Administration, between 2008 and 2019. I am not going to tell this committee that it doesn't have the responsibility that it views, but that responsibility is enormous. And I have been blessed to serve on committees that took 3 years to change the rules of discovery. And if this committee is going to engage in doing what it's going to do, I hope that we will be involved and it will be a deliberate process.
Members' questions? Yes, Chairman Dutton.
I have one, thank you. You were talking about the number increase in trucks on the road, and I guess I wondered, has there been an increase in the number of truck citations or something for not having all the right equipment or not having effective equipment on a truck?
There have, and I don't have that at my ready fingertips, Chairman Dutton, but I did come across that statistic, and I don't want to misspeak, but I think, without holding me to it, that some 70% of trucks that are pulled over by Texas DPS are cited for a violation.
Yes, okay. All right, thank you.
Members of
Thank you for the committee's time.
Yeah, Representative Schofield.
Just very briefly, at the beginning of your testimony, you mentioned that you were working on the third restatement of torts. When was the second restatement of torts?
It goes even further back, because we have 402A that was developed by Dean Keaton, and so I believe that 402A came to us in the mid-'60s.
Right. And I believe that Chairman Leach is willing to be deliberative, but I don't think we can wait that long. Sine die is May 1st.
Thank you, Representative.
Okay, thank you. Thank you, Jim. Appreciate it. Members, any other questions? Hey, Jim, actually, before I let you go, can you just state again your name, your position, who you're representing, and your position on the bill?
Yes, Mr. Chairman. And I come close to calling you Your Honor as well, and so I heard Mr. Smith make that mistake, and this is just a force of habit. Yes, Mr. Chairman, it's Jim Perdue, Jr., Texas Trial Lawyers Association and for myself against the bill.
Okay. Thank you.